The Divorce Act has recently undergone major changes, which came into effect on March 1st, 2021. Our team of divorce lawyers can help you determine if and how these extensive changes to the law will affect your divorce. Keep watching. Changes to terminology. One of the major changes to the law is the use of different terminology relating to the care of children. The term decision-making responsibility replaces the term custody. Rather than an order for sole or joint custody of a child, you may receive an order for sole, joint, or divided decision-making responsibility related to a child. The term access is replaced by the term parenting time. Parenting time is the time when a child is in the care of a parent. The parent does not need to be physically present the entire time. For example, the time that your children spend at school or daycare can still fall within your parenting time. Family violence. Extensive changes have been made to the Divorce Act to ensure that family violence concerns are taken into account as necessary. The legislation now contains a detailed definition of family violence and requires a court to consider any family violence and its impact on the child during a determination of the best interests of the child. Other additions to the legislation relating to family violence deal with the following: supervised parenting time or supervised transfers, orders prohibiting the removal of a child from a specified geographical area without the written consent of the other parent or court order, exceptions to notice provisions regarding change of residence or relocation for cases involving a risk of family violence, coordination between criminal, child protection, and family cases, relocation applications. Those who are hoping to move to another town, province, or country with their child will have to navigate a new approach to relocation applications. Significant changes have been made to both the procedures that must be followed by an applicant and to the methods that judges will use to make their decision. There are now stringent notice requirements that apply to parents with an existing order for custody, access, parenting time, or decision-making responsibility that was made under the Divorce Act. The parent who wishes to relocate must provide notice at least 60 days before the planned relocation, and the other parent, if they object to the relocation, must respond within 30 days. Other changes. Many other changes have been incorporated in the legislation to increase the efficiency of the law and make the law easier and more affordable for individuals to access. These changes include the following: encouraging the use of out-of-court dispute resolution processes, including mediation services and collaborative law; authorizing the government to designate a provincial child support service to calculate child support; simplifying procedures for obtaining, varying, or enforcing a support order when the parents live in different provinces or countries, interjurisdictional support orders; improving the mechanism used to recalculate child support; improving the access to the law in both official languages; incorporating 2 Hague Family Law Conventions relevant to resolving family law issues when one parent lives in another country; improving access to income information for use in support applications. Many of the recent changes to the Divorce Act are only relevant in very specific circumstances. If you have concerns about how any of the changes to the Divorce Act will affect your divorce or any future applications affecting your children, contact one of our divorce and family law lawyers today. And if you found this video helpful, be sure to like, comment, and subscribe.